Hello everyone. As you all are aware that we are daily posting videos of important case related MCQs. In furtherance of that, in this video we will discuss tort MCQs case related. Question number 1 is in Ashby versus White is a leading case to explain the maxim a injuria sine daemonum. Question number 2. In which of the following cases explain the maxim injuria sine daemonum? The correct answer is Bhim Singh versus State of Jammu and Kashmir. Question number 3. The principle of ubi jus ibi remedium was recognized in Ashby versus White. Gloucester Grammar School case explained the principle of daemonum sine injuria. The principle of ubi jus ibi remedium was recognized in, it is a repeated question, in Ashby versus White. The maxim injuria sine daemonum has been explained in the following case. Answer is Ashby versus White. If it was lawful act, however ill the motive might be, the defendant had a right to do it. This observation was made by the court in one of the following case. Correct answer is A. Mayor of Bayford Corporation versus Pickles. Which of the following are important cases on maxim daemonum sine injuria? Answer by using the quotes below. Correct answer is A. Dixon versus Reuters Telegram Company. If lawful act does not become unlawful even if it was done with evil motive, this was held in B. Mayor of Bradford Corporation versus Pickles. Ashby versus White is a leading decision explaining the maxim of injuria sine daemonum. Which of the following case is not an instance of injuria sine daemonum? Correct answer is C. Mogul Steamship versus McGregor. This case doesn't explain the instance of injuria sine daemonum. Otherwise, all these Ashby versus White, Marazati versus Williams, Bhim Singh versus State of Jammu and Kashmir, these all cases explain the injuria sine daemonum. Now we will move towards the question number 12. Which one of the following case is not an instance of daemonum sine injuria? Correct answer is D. Ashby versus White. By using the code below, match list and list second and select the correct answer by using the codes given below. Bhim Singh versus correct answer for this question is C. In C we will see Bhim Singh versus State of Jammu and Kashmir. A. Injuria sine daemonum. Municipal Corporation, correct answer is res spellicator. In Nicholas versus Marshland, correct answer is vis major. And Mogul Steam Company versus McGregor Go and Company, correct answer is daemonum sine injuria. This we have already discussed. General defenses. Which one of the following famous case is related to an exception to the application of the doctrine voluntary non-fit injuria based on rescue cases? Correct answer is A. Haynes versus Hardwood. In which of the following cases the House of Lords held that voluntary non-fit injuria had no application to harm sustained by a workman from the negligence of his employers is not warning him of the moment recurring danger, although the man knew and understood that he personally can risk of injury if and when the danger did occur. The correct answer is A. Smith versus Baker. Following are the good defenses to an action in torts. The correct answer is C. 1 and 3rd. A. Voluntary non-fit injuria. C. Vis major. These are the good defenses for action in torts. Scientific non-fit injuria is not a good action in tort. Which of the following cases is an authority on rescue cases an exception to maxim voluntary non-fit injuria? Correct answer is A. Haynes versus Hardwood 1935. Match list 1 and list 2. Name of the defense and case laws. Act of State, Buron versus Damnum. Consent, the correct answer is Hale versus Brookland and Auto Racing Club. Act of God, Nicholas versus Marshland. Statutory authority, correct answer is Metropolitan Asylum Board versus Hills. Again, we will discuss the again it's list 1 and list 2, defense in torts and related cases. Correct answer will be voluntary non-fit injuria, Samira Kohli versus Prabha Manchanda. Judicial acts, Anwar Hussain versus Ajay Kumar. Act of State, Vinod Kumar Shantilal versus Gosalia versus Gangadhar Narsing Das Agarwal. And necessity, correct answer is Olga Tellis versus Municipal Corporation, Bombay. Match list 1 and list 2. Here again we will see list 1 and list 2. Correct answer for plaintiff, a wrongdoer. The correct answer is Consolidated Company versus Curtis. And Act of God, correct answer is Nicholas versus Marshland. Inevitable accident, correct answer is Stanley versus Powell. Mistake, correct answer is Bird versus Holbrook. Liability of a state. Vidyavati versus State of Rajasthan is a case relating to vicarious liability of the state. Case of Kasturi Lal versus State of UP is related to vicarious liability of state. P&O Steam Navigation Company versus Secretary of State for India is a leading case on vicarious liability of state. The case of Ratlam Municipality versus Vridhi Chand is related to tortious liability of municipal corporation. In which of the following cases did the Supreme Court of India give the ruling that sovereign immunity of the state is subject to the fundamental rights? Correct answer is C. People Union for Democratic Rights versus State of Bihar. In which case it was rated at Supreme Court that state was not liable on the ground that police were acting in discharge of statutory powers, and power of police in keeping the property in police malkhana was a sovereign power. Correct answer is C. Kasturi Lal versus State of. The police officer failed to observe the provisions of UP police regulations in taking care of the gold seized. The injury had been committed by the employees of the state during the course of its employment, but the employment was in a special category of sovereign power, so the claim was not sustainable. It was held by the Supreme Court in Kasturi Rela Ram Jain versus State of UP. In which of the following case did the Supreme Court of India give a ruling that sovereignty immunity of the state is subject to fundamental rights? D. People Union for Democratic versus State of Bihar. In which of the following cases the court stated that in modern sense the distinction between sovereign and non-sovereign powers does not exist? Correct answer is C. N. Nagendra Rao and Company versus State of Andhra Pradesh. In which of the following cases did the Supreme Court rule that the principle of sovereign immunity will not apply to the proceedings for award compensation for violation of fundamental rights? Correct answer is D. Neelabati Behra versus State of Odisha. Compensation can be awarded to a person who suffered personal injuries at the hand of government officers which amounted to tortious act. It was held in C. Rudal Shah versus State of Bihar. Borhill versus Young is a famous case for nervous shock and remoteness of damages. The leading case in which the test of directness for determining remoteness of damages was finally established is Re Polymus and Furnace Vidhi and Company. In which of the following cases the jurisprudential basis of principle to award compensation for the violating human rights has been laid down by the Supreme Court? Neelabati Behra versus State of Odisha. Important case है ये. The rule currently followed in India to determine remoteness of damages was laid down in B. Overseas Tank Ship UK Limited versus Mott's Dock Engineering Company Limited. The rule laid down in Ray Polymus case is that defendant shall be liable for all direct consequences of his act if he could foresee some damage to the plaintiff from his act. Match list 1 and list 2. List 1 consists of the Wagon Mount case, Re Polymus and Furnace Vidhi Company Limited, Scott versus Sheffield, and Farden versus Harcourt Rivington. And the correct answer is B, which says for option A. Second option is correct. The Wagon Mount case, the test of reasonable foresight, and the Ray Polymus and Furnace Vidhi Company. This is the test of directness. Scott and Sheffield. Correct answer is remote but proximate. And Fendon versus Harcourt Rivington. The correct answer is reasonable foreseeability. Strict and absolute liability. Rule of strict liability was laid down in. Correct answer is Rayland versus Fletcher. The rule of strict liability is contained in Rayland versus Fletcher. बहुत important case है. The case of Rayland versus Fletcher was laid down the principle of strict liability of landowner. Which of the following case does not constitute an exception to the rule of Rayland versus Fletcher? D. Poor condition of land. Otherwise, these all are the exceptions. Act of God, malicious act to stranger, plaintiff's own fault. The decision given in MC Mehta versus Union of India is on absolute liability. The rule laid down in Rayland versus Fletcher is not applicable to all of the above. We will see the option. When the escape is due to vis major or act of God, when the damage is due to wrongful or malicious act of stranger, when the escape is due to plaintiff's own fault. This is the exception which we have discussed so far in earlier case of questions. The rule of absolute liability was first laid down in MC Mehta versus Union of India. In which of the following cases the rule of absolute liability was laid down by the Supreme Court of India was followed? Correct answer is C, both A and B. And A, option A is Indian Council for Environment Legal Action Union of India, AIR 1996. And option B is Claus Mittelbraschiet versus East India Hotels Limited AR 1997. The rule of absolute liability was laid down by the Supreme Court of India was followed. In which of the following cases the Supreme Court of India applied the principle of absolute liability? Give the answers. Correct answer is B, B, C and D. Absolute liability is applied. Charanlal Sahu versus Union of India, Indian Council for Environment Legal Action versus Union of India, MC Mehta versus State of UP. The Supreme Court laid down in MC Mehta versus Union of India, correct answer hai, that where the enterprises engage in hazardous or inherently dangerous activities and harm result to anyone on account of accident, the enterprise is strictly liable to compensate all those who are affected by such accident. This was decided in MC Mehta versus Union of India. The Supreme Court ruling in Shriram Chemical Case 1978 is famous for laying down the absolute liability rule. The rule of absolute liability was laid down in the case of MC Mehta versus Union of India. It is well known English case Rellens versus Fletcher 1808. The principle of strict liability was propounded. The principle was developed into a principle of absolute liability in a case by the Supreme Court. Name the case. MC Mehta versus Union of India, AIR 1987, also known as oleum gas leak case. Rule laid down in Rellens versus Fletcher is also known as strict liability rule. Negligence. The rule regarding the principle of negligence was laid down in the case of B. Dongue versus Stevenson. In Dongue versus Stevenson, the duty of manufacturer was fixed towards ultimate consumer. Which of the following case established a civil law tort of negligence and obliged manufacturers to have a duty of care towards their customers? The correct answer is Dongue versus Stevenson. Doctrine of res ispa liquidator was applied by the Supreme Court in Municipal Corporation of Delhi versus Subhagwanti. Doctrine of alternative danger was explained in Jones versus Boyce. The verdict of the Dongue versus Stevenson was delivered by the following judge, Lord Atkin. Important hai. Andhra Pradesh State Road Transport Corporation versus K. Hemlata and Municipal Corporation Greater Bombay versus Lakshman Iyer. Important case decided by the Supreme Court, the rule of contributory negligence. The manufacturer's liability principle was laid down in Dongue versus Stevenson 1932. The neighbor principle was laid down in the landmark case in Dongue versus Stevenson. The case Dongue versus Stevenson was decided by the House of Lords. In which of the following cases did the Court of Exchequer can explain the principle of res ispa liquidator? Correct answer is Scott versus London and St. Catherine Dock Company. Match list 1 and list 2. List 1 says that a patient is a consumer. Doctor's duty to doctor's duty to maintain mercy. C, free service. D, contract of personal service. And correct answer is A. A's correct answer is 1. A patient is a consumer. It decided in Vasanta P. Nair versus Srimati V. P. Nair. Doctor's duty to maintain secrecy. The correct answer is K. Rangaswamy versus Jaya Vittal and others. Free service, correct answer is patient is a consumer. Correct answer is Vasant P. Nair and Srimati V. P. Nair. Doctor's duty to maintain secrecy. Correct answer is Dr. Tokuga versus Apollo Hospitals and Enterprises Limited. Free service, correct answer is Indian Medical Association versus VP Shantaba. And contract of personal services, correct answer is K. Rangaswamy versus Jaya Vittal and others. Match list, list 1 and list 2. List 1 says that last opportunity. B. Apportionment of damages. C. Alternative danger. D. Identification. Correct answer this is the name of the rule and related case will be last opportunity, Davies versus Mann. Appropriate of damages, Vidya Devi versus MP Road Transport Corporation. Alternative danger, Shyam Sundar versus State of Rajasthan. Identification, Barmina Mills versus Armstrong. Case of Abarnath versus North Eastern Railway Company is about malicious prosecution. Holborg Hotel versus Scarbourg Borough Council is a leading case on nuisance. The tort involved in Hearst versus Picture Theatre Limited is a case on trespass. Arrange the following case in chronological order by using the codes. Correct answer is B, C, D, A. This means that Shyam Sundar versus State of Rajasthan first, Pushpa Bai versus Ranjit Ginning and Pressing Company second, Sayyid Akbar versus State of Karnataka third, and Municipal Corporation of Delhi versus Shushila Devi, this is fourth. Arrange the following cases in the chronological order. Correct answer is B. The first case is the Secretary of State for India Council versus Hari Bhanji first, the State of Rajasthan versus Vidyavati second, State of Gujarat versus Mainan Muhammad third, Rudal Shah versus State of Bihar fourth. Next question. Arrange the following Supreme Court decisions on the justification of torts in chronological order by using the quotes given below. Correct answer is C. Here the first case will be Anwar Hussain versus Ajay Kumar. And the second case is Vinod Kumar Shantilal Gosalia versus Gangadhar Narsingh Das. And third case will come by chronological order is Sodan Singh versus New Delhi Municipal Corporation. And the fourth case will be Nizam's Institute of Medical Sciences Prashurnath S. Dhanaka. This will be fourth. Which of the following is a leading case on the trespass ab initio? Correct answer is 6 Carpenter's case. In which of the following case it has been held that Section 9 of Civil Procedure Code 1908, which enables a civil court to try all suits of civil nature, impliedly confers jurisdiction to apply the law of torts as a principle of justice, equity and good conscience. Correct answer is Union Carbide Corporation versus Union of India. Uninsured vehicles are also within the scope of Section 165 of Motor Vehicle Act was held in C. Per Premanand Thakur versus Commissioner Coal Mines 1988. Consider the following statement. The Bolitho test relates to medical negligence. The Bolitho test was referred in Malay Kumar Ganguly versus Sukumar Mukherjee. Choose the correct option from below. Both 1 and 2 are correct. Bolitho test led to medical negligence. The Bolitho test was referred to in Malay Kumar Ganguly versus Sukumar Mukherjee. The eggshell skull principle was applied in C. Smith versus Leach Brain and Company. In which of the following case Lord Wilberforce opined that it is necessary to consider 3 elements inherent in any claim for nervous shock: the class of persons whose claim should be recognized, the proximity of such persons to the incident, and the means adopted which shock is caused. The correct answer is McLogan versus O'Brien. The right of a person to recover damages for nervous shock sustained while he was not present at the scene of grievous injuries to his family but comes upon them at an interval of time and space was for the first time recognized by the House of Lords in England in B. Mauduglin versus O'Brien. The right of public in a highway is merely a right to pass and repass, and that so long as that right was not inferred, they cannot complain that of what was in air above on the earth beneath it. In which of the following cases this observation was made? Correct answer is Noble versus Harrison 1926. There is no reason why compensation for non-pecuniary damages should not be allowed. This was held by the House of Lords in the case Parley versus Skinner. Match list 1 and list 2. Dongue versus list 1 is Dongue versus Stevenson. B. Cassidy versus Daily Mirror newspaper. C. Merriweather versus Nixon. And D. Bird versus Jones. List 1 is case and list 2 is tort. Correct answer will be for A. Dongue versus Stevenson. The correct answer is negligence. Cassidy versus Daily Mirror newspaper. The correct answer is defamation. Merriweather versus Nixon. The correct answer is joint tortfeasors. Bird versus Jones. The correct answer is false imprisonment. Match list 1 and list 2. List 1 says Mercy Docks versus Porter. B. Metropolitan Asylum District versus Hill. C. Nicholas versus Marshland. D. Holmes versus Mather. Correct answer is Mercy Decks versus Porter. Vicarious liability. Metropolitan Asylum District versus Hill, Statutory Authority. Nicholas versus Marshland, Act of God. Holmes versus Mather, Inevitable Accident. Match list 1 and list 2. List 1 says vis major, B res liquidator, C actionable claim per se, D voluntary non-fit injuria. And list 2. Vis major, correct answer is scienti non-fit injuria. So, vis major, sorry, act of God. Res liquidator, correct answer is negligence. Actionable per se, correct answer is trespass. Voluntary non-fit injuria, correct answer is scienti non-fit injuria. I will repeat once again. Vis major, act of God. Res liquidator, correct answer is negligence. Actionable per se, correct answer is trespass. Voluntary non-fit injuria, correct answer is scienti non-fit injuria. List 1 and list 2. List 1, Gillick versus West, Norfolk and Weisbeck Area Health Authority. B. Wagon Mount. C. Ashby versus White. D. MC Mehta versus Union of India. E. Priestley versus Fowler. Correct answer is A. Priestley versus Fowler. Correct answer is Doctrine of Common Employment. MC Mehta versus Union of India. Correct answer is absolute liability. Ashby versus White. Correct answer is violation of absolute rights. Wagon Mount. Correct answer is remoteness of damages. And Gillick versus West, Norfolk and Weisbeck Area Health Authority. Correct answer is voluntary non-fit injuria. List 1 and list 2, principal. List 1, list 2nd, associate case. List 1, dominant sign injuria. B, absolute liability. C, injuria sign dominant. D, inevitable accident. Correct answer is D. Dominant sign injuria, Gloucester grammar case. Absolute liability, MC Mehta versus Union of India. Injuria sign dominant, Ashby versus White. Inevitable accident, Stanley versus Powell. Match list 1 and list 2. List 1 says A. Relland versus Fletcher. B. Donahue versus Stevenson. C. Gloucester Grammar School case. D. Rose versus Ford. The correct answer is C. In Rose versus Ford, the correct answer is compensation for pain and Rose versus Ford, compensation for pain and suffering. Gloucester Grammar School, loss caused by competition in business. Donahue versus Stevenson, liability for negligence. Relland versus Fletcher, strict liability. Again, match the following list 1 and list 2nd. List 1, injuria sign damnum. B, damnum sign injuria. C, strict liability. D, defense of consent. The correct answer is injuria sign damnum, Ashby versus White. Damnum sign injuria, Gloucester's case. Strict liability, Relland versus Fletcher. Defense of consent, voluntary non-fit injuria. Match list 1 and list 2. List 1, Donahue versus Stevenson. B, In re Polymus. C, MC Mehta versus Union of India. D, Lloyd versus Gray Smith and Company. Correct answer is D. Lloyd, Grace and Smith and versus Company, vicarious liability. MC Mehta versus Union of India, absolute liability. In Ray Polymus case, correct answer is remoteness of damages. Donahue versus Stevenson, correct answer is neighbor principle. Match list 1 and list 2. Relland versus Fletcher, correct answer is liability without fault. Borhill versus Young, correct answer is negligence. Strukes versus Bridgman, correct answer is nuisance. Newstead versus London Express, correct answer is defamation. List 1 and list 3. Municipal Corporation versus Subhagwanti, correct answer is Supreme Court. Roop Lal versus Union of India, correct answer is High Court of Jammu and Kashmir. Steve versus Chiranji Lal, correct answer is High Court of Madhya Pradesh. Rural Transport Service versus Bezul BV, correct answer is High Court of Calcutta. Question number 28. Match list 1 and list 2nd. List 1 consists of Indian Council for Enviro Legal Action Union versus Union of India. B. Relent versus Fletcher. C. Lakshmi Rajan versus Malar Hospital Limited. D. Union of India versus United Insurance Company Limited. Correct answer is Indian Council for Indian Council for Enviro Legal Action versus Union of India. Correct answer is absolute liability on enterprise carrying on hazardous and inherently dangerous activity. Reliance versus Fletcher. Correct answer is liability for keeping dangerous things on land. Lakshmi Rajan versus Malar Hospital Limited. Correct answer is patient's consent for operation did not imply consent to the removal of her uterus. Union of India versus United United Insurance Company Limited. Correct answer is contributory negligence of driver cannot be imputed to passengers. So this was the last question. In this tort, we have discussed MCQs of tort. Thank you for watching entire video and giving your appreciation. Please follow us by subscribing us. Thank you so much. Thank you for watching.